Good evening and good morning and good night as well to everybody here. My name is Aurélien Orange. I'm with my colleague from the Corax Foundation. Today we have a match of the eighth of finals between two teams in Australia and in Canada. So I give the floor to my colleague who will be hosting the match.
Indeed, good morning, good evening, and good night to everyone. It is a pleasure to welcome you to the eighth finals match between the debate teams of University of Manitoba from Canada and University of Melbourne from Australia. A welcome and well done to the teams of getting to the final phase of the Hagen University Law Debate Tournament 2023. My name is Anna Maria Urbanova, and on behalf of Quirks Foundation, the organizer of competition, I'll be your host for today's session. So just a short reminder or introduction to those not familiar with the match. The debate statement was released to the team 7 days prior. They have both prepared for both sides of the argument. In a short while, they will discover which part they will represent during the match. The debate statement for the session is: people do not have the right to restrict access to their image, as it is an external manifestation and thus part of the public domain, and the current application of intellectual property rights supports this interpretation, despite potential concerns over privacy and control of personal information. And that would be all from the introduction on the organization side. It is now time for the students to introduce themselves, starting with University of Manitoba's debate team, Mr. Liam Brown.
Hello, thank you again for having us. I think we have at least 2 days and many time zones on this call, so we appreciate everybody accommodating that, and we're super excited to keep moving in the elimination rounds.
Thank you and welcome from University of Melbourne. Joining us, Ms. Jolene Bob.
Hello, everyone. I'm quite excited about this match, and I'm a second-year JD student at University of Melbourne. Thank you.
Thank you and welcome for joining us from University of Manitoba as well, Ms. Diana Gutierrez.
Hi, everyone. Happy to be here. I'm in my second year at Robson Hall, and I just want to extend my congratulations to our friends from Melbourne for making it to this elimination round, and we look forward to this debate with you.
Thank you and welcome from University of Melbourne, Mr. Ilan.
Hello, everyone. I'm Elon. I'm a third-year JD student here in Melbourne. Hello to my friends in Winnipeg. It was a tough loss last night, but I wish you guys all well today.
All right. So a competitive spirit already. From University of Manitoba, also joining us, Mr. Stefan Licht.
Yes, good morning and good night to most of my colleagues on this call. No, I'm just kidding to everyone. Yeah, thank you so much for accommodating our request to move the round. We had exams, and so that really that meant a lot, and I know that it's tough for everyone. So I just want to say thank you very much for that. And yeah, I'm looking forward to the debate.
Great. Indeed. Thank you very much, everyone, for cooperating to be able to reschedule the match for this session. All right, in a few seconds, you will see the allocation wheel for the allocation of positions. As per usual, each team has two possibilities, one in favor, one against. So in a short while, you will know which position you will have during the debate. All right, for today's eight finals match, the in favor position in the statement, people do not have the right to restrict access to their image as it is an external manifestation and as part of the public domain. And the current application of intellectual property rights supports this interpretation despite potential concerns over privacy and control of personal information will be represented by a debate team of University of Melbourne. As such, the debate team of University of Manitoba will be defending position against. Now you will have 5 minutes to finalize your preparations. Feel free to close your cameras and take the time to prepare. Best of luck. right, thank you everyone. Your final time for preparation has now concluded. We'll be starting the match shortly. Just a short reminder for everyone watching. Yellow paper means 30 seconds remaining of the speaking time. Red paper means the speaking time is over. The speaker can comfortably conclude their sentence, but it's not recommended to start a new one. That said, starting with the position in favor, the debate team of Melbourne University, you have 4 minutes for your opening statement.
Good morning, good evening to our honorable judges and friends around the world. Our position is one that relates to people not having the right to restrict access to their image. It's an important point to make that we as people are living in a world that is consistently changing and evolving into new spheres of what used to be only the internet is now also public and private space. That being said, it must be known that for AI to effectually act in the world, it must receive input from the internet, right? That is how AI learns and it adjusts to its understanding of how to create an image or how to create data points for other people to use and share. It is important to note that in the US Constitution's copyright mandate, the idea is to promote the progress of the arts and sciences. To promote the arts and progress, it is necessary for people to use a public domain space to promote and spread their information by publishing that space. That space is therefore already under legislation that protects intellectual property rights. There have been many cases since the advent of ChatGPT that developers have posted and then sued certain AI companies, claiming that the companies were infringing on their copyrights. It has been said in many cases that this is not the case. For instance, art is in the style of the beholder, was one of the judgments that was given recently. A second one, the scanning of millions of copyright protected books, was the Authors Guild sued Google for that. The court said that transforming use, something new with a different purpose and character, was necessary for the arts and sciences to progress. If all of a sudden we start to say that the public domain is a place that is restricted access, and when you post something that you then therefore have no ability to use what I've posted, we will become a state that restricts open access and sharing information. In the WHO's treaty process relating to vaccine sharing, the point that the countries made, especially countries that do not have the same ability to share information as wealthier nations, they said that we must allow sharing of access in an open forum. That open forum extends to individual right, because part of that information is having the knowledge of if a vaccine is effective or if it is not. These abilities for countries to see and to share their knowledge is necessary in a public domain. The current intellectual property framework protects this. If you are to say that your copyright has been infringed upon, you have courses of action. You have a breach of contract, possibly, if someone was to take information off a website and say that they were using it under their own name. You also have real property. You have trespass to property in the virtual reality worlds. All of these areas already protect intellectual property, and to create a new framework that would extend beyond what the framework already is in place only would cause more problems, because you would have different countries issuing different laws, which would then affect the public domain into a controlling forum. That is the last thing we want in a world filled with content creators.
Thank you very much. For the position against the debate team of University of Manitoba, you have 4 minutes for your opening statement.
Everyone hear me?
Yes.
Okay. Good afternoon, good evening, and good night to our estimable colleagues and all those watching. So first of all, I would just like to start by acknowledging that while AI and open forum platforms are relevant to the topic of the debate today, we actually don't think that's the heart of the issue at stake today. We think this debate is about a much more fundamental and much more critical right to privacy that all of us hold and must be acknowledged. So having the right to choose who sees pictures of you and what people do with those images is a critical component of the right to privacy. As mentioned in the submission of my learned friend, digital technologies have made the right to privacy a more pressing concern now than at almost any other point in human history, as private images and private information can be disseminated globally almost instantaneously. The right to privacy has been protected and recognized domestically and internationally by governments and organizations around the world. In Canada, Section 8 of the Charter of Rights and Freedoms gives protection against unreasonable search and seizures, but it's also been widely interpreted to incorporate a right to privacy that is critical to the liberty component of Canadians. Furthermore, the International Covenant on Civil and Political Rights, Article 17, states that no one shall be subjected to arbitrary or unlawful interference with the right to privacy. Furthermore, privacy has been enshrined, a right to privacy has been enshrined in Article 12 of the UN Declaration of Human Rights and in Article 8 of the European Convention of Human Rights, which gives the right to respect private and family life. Indeed, in a recent decision by the European Court of Human Rights, KU versus Finland, essentially someone had uploaded images of a person onto a dating website and without that person's knowledge or consent. The European Court of Human Rights ruled that this state has a positive obligation to ensure that an individual's right to privacy is not being violated. A positive obligation illustrates how important the right to privacy is and how stringent protections of it need to be. Furthermore, in Robin Rihanna Fenty, best known as Rihanna, the singer of Love on the Brain and other great hits, versus Arcadia Group Brands, there was a T-shirt by the Top Hat line of clothing which bore her image and was being sold without her authorization. And because the T-shirt had her image on it, that was misleading people into thinking that she endorsed the product and thought it was stylish. And that was ruled as a violation of her intellectual property and was a misrepresentation by the brand, and they had to cease production of the shirt and pay compensation to Rihanna. So, but what exactly are we talking about when we're dealing with the right to privacy? We, of course, acknowledge that the private and public domains are two separate spheres. However, every time you're outside of your home, are you giving up all of your image rights? Are you giving the government or private organizations the right to surveil you? We, on side opposition, would argue that one has an objectively reasonable expectation of privacy in many public settings and public spheres, and that must be upheld. My colleagues will be expanding on these further topics of the right to privacy today by talking about the right to privacy for public figures and also the right to privacy for people generally. Ladies and gentlemen, because this motion would unreasonably erode an individual's right to privacy, because this motion would unreasonably extinguish image rights and image protection, and because this motion would unreasonably grant far-ranging surveillance powers to both private corporations and public governments, we are proud to oppose. Thank you.
Thank you very much. This now concludes the opening statements. We are now entering the first rebuttals. The debate team of University of Melbourne, you have 2 minutes.
My learned colleague in Winnipeg, thank you so much for your opening statements. Unfortunately, we will have to oppose your position. And firstly, I must say that the right to privacy and the public and private sphere is no longer as cut and dry or black and white, particularly when it comes to posting on the internet. We have websites like 4chan and 8chan, websites that are considered the dark web, websites that are considered areas that promote criminal activity. And that is why it is necessary for there to be a restriction on your external manifestations. It is to protect those that are vulnerable to those manifestations, like you said. And that is why the public and private sphere must be left alone as it is. You do not have a right to protect your image. And that does not mean that governments have carte blanche to then access your image. That's why we argue that legislation that is currently in place that protects intellectual property rights is also extendable onto those that protect the internet and the open access of the internet. In Australia, you have legislation, especially in Victoria, where our law school is, the Charter of Human Rights in 2006, that protects a person's privacy. However, it does not extend to a person's criminal behavior. And that's why there must be a monetization and for people to be monitored on these websites. Thank you.
Thank you very much. For the first round of rebuttal, debate team of University of Manitoba, you have 2 minutes.
Thank you to my learned colleagues and to the panel. Before I get into my submission, I would like to address something brought up by my learned colleague. He seemed to insinuate in his speech that there should be no anonymity online whatsoever, because the dark web and other websites can facilitate criminal behavior or very unsavory activity. I don't disagree with that, but the notion of anonymity online has far-reaching consequences, and many people around the world need anonymity online to express their views, to politically, religiously, and to be who they are in many respects. And we think that would be quite a dramatic step. But moving on to my submission, that there are many justifiable, legally and morally justifiable protections of one's likeness. And I'm going to be focusing on public figures, while my colleague Diana will be speaking about what it means to everyday people. There are jurisdictions across the world explicitly protect people's likeness and the right of photography to be protected against photography, but also the distribution and use of that image. For public figures, they have a right not to be put in ad campaigns or posters or promotions without their permission. And this exists to protect their commercial interests, but also their dignity as human beings. The digital age has extended this even further. Cases like von Hanover v. Germany at the European Court of Human Rights acknowledge that it doesn't even need to relate to commercial activities. One has a right not to be harassed and photographed constantly. And if you look at this in a whole other realm, something like deepfakes, if your image is truly public domain and can be used by others in whichever way they please, they can make a deepfake of me or a public figure or anyone else saying and doing anything, because that is the nature of a deepfake. And that would be deeply damaging and have far-ranging consequences. We're proud to oppose this motion. Thank you.
Thank you very much. For the second rebuttal, the debate team of University of Melbourne, you have 2 minutes.
Thank you, Judge and colleagues. So as you say, that's why people do not have the rights to restrict their access to the image, especially when they are posting on the social media platforms. I want to focus on that point. So it is increasingly common for someone to get photographed without any permission, and their image is being uploaded into the public domain without their consent or even their knowledge. So although I know the intellectual property law protects the owner of the image, but once you upload it into the public domain, you lost that control over that image. That's because when you sign up the social media platform like Facebook or Instagram, you will agree to grant a non-exclusive license to the world to use any content you post on the site. On Twitter, this is even crazy. You have more freedom to use the image. You can modify and adopt any image you post online. So you basically lose all the control over your images. You can't stop them to use your image once you post online. Thinking of the case when a secondary school kid upload a photo in the funeral. Thinking of someone take a photo of a family when the baby is in a pram. So all those cases, people do not have their rights to restrict access. So that's why we need to change the legislation to protect those vulnerable people and regulate people's behavior to both balance the freedom of expression and protect people's privacy. Thank you.
Thank you very much. The debate team of University of Manitoba, you have 2 minutes for your second rebuttal.
Thank you. I'll agree that this issue isn't cut and dry. But despite the difficulties of the digital age, it doesn't mean that people don't have protections outside of monetization interests, and that these rights don't disappear once pictures are posted online. We've noted several instruments that protect people's right to privacy. This is because it's fundamental and inalienable and should not be interfered with casually. When it comes to social media, as our friends have posted, we have to grant consent for people to tag us in pictures or even to see whether we're publicly searched. This, in fact, implies that we have the right to either grant access or restrict our images. In the European Court of Human Rights case of Suschel in Austria, it was found that the notion of a private life includes a picture because a person's image is an element that is important to their identity. This also applies to instances that are captured by accident, which our friends mentioned. Recently in Ontario, a woman was able to successfully sue a production company that used an image of her running in their campaign. The production company tried to argue that it would be inconvenient to get consent from all of these people. However, this was not considered by the judge, and it found that posting her picture publicly was indeed an invasion of privacy. Furthermore, we would note that there is legislation that grants people the right to eliminate their information from the online world. For instance, in 2014, the European Court of Justice affirmed the right of an individual to ask for search engines such as Google to delist their names. In 2015, Russia passed a law allowing citizens to delist from search engines. This was also similar in Turkey and Serbia. And most recently in 2018, the EU affirmed in Article 17 of the General Data Protection Act that people, not individuals, have a right of erasure. Therefore, it is clear that individuals do have a right to their image, do have a right to restrict, which is why we oppose this motion. Thank you.
Thank you very much. This now concludes the rebuttals. Entering the conclusions, the debate team of University of Melbourne, you have 2 minutes.
Thank you, everyone. So to sum up, people do not have the rights to restrict access to their image with the current application of the intellectual property rights on the following 3 grounds. First, the intellectual property law protects the artist's creation, but not the image, not the people inside the image. As we discussed for both sides, we all know the domestic intellectual property laws and also international agreements all covers that. They provide protection for the image owner in terms of their knowledge, their skills, and their creativity, but not the person in the image. Secondly, even so, we know the intellectual property laws protects the people's image as an owner to a certain extent. But when you are using the social media or other online platforms, people's rights may not be retained because they give up the rights. Thirdly, with the new technology developed in the digital age, the law has not been up to date to protect people's rights. Taking the digital asset as an example, unauthorized minting of the NFT can be argued as a creation of an NFT, but it's not a recreation of the underlying asset, which is the image itself. So the owner of the image may not have the rights to restrict access to their image in the digital asset world. Therefore, the intellectual property rights becomes more and more important globally. We do need legislation to protect them, especially protect the vulnerable people, and also allow them to have the rights to restrict access to their image when it's needed. Thank you.
Thank you very much. For the conclusion of the debate team of University of Manitoba, you have 2 minutes.
Thank you, esteemed panel and colleagues. I do believe with do agree with my opponent's belief that this is about protecting people, which is why to conclude this debate, I will be asking a very important question. Who deserves protection and when? I think When the government spoke to us today, they had a lot of concerns about the ownership of creators, and those are valid, but they took a very bold stance, and there are lots of implications to that. When asked who deserves protection, the proposition today answers essentially nobody. Not women's rights activists in Iran who wish to remain anonymous online, not Canadians or Australians walking down the street who don't want to be surveilled illegally. Nobody appears to be the answer for the proposition, because if you're in it, you have no rights. The opposition today have presented to you numerous cases where that, as a matter of fact, has not been accurate. But additionally, we've explained to you that principally, your persons is intimate, much like your fingerprint or a hug you give, or your wife or your husband. These are things that are core to who you are and very important, and they should not be taken away so haphazardly. And moving on to a second question, when do people need protection? Well, the proposition, because they, at the outset of this debate, did not strictly define what they were referring to, we have to assume they mean a quite broad interpretation. So never is the answer for the proposition. The opposition, we believe, at least in private, you should be expected to maintain your likeness and your privacy, at least and especially in private. So when we look at this debate about who is protected by this motion, and or more accurately, who is exposed in this motion, we believe the opposition is clearly superior. Thank you.
Thank you very much. This now concludes your debate for the 8th finals match of the final phase of the Hague Inter-University Law Debate Tournament 2023. Well done to both teams. You can now relax, turn your cameras on. We'll be shortly entering the feedback session. Good job to both teams on reaching the final phase, and it's been a pleasure hearing your arguments for this debate. I hope you had an interesting time for preparation and that you enjoyed the competitions thus far. So without further ado, giving the floor to the debate team of University of Manitoba first, Ms. Diana Gutierrez, how did you find the debate, the preparation, and is this perhaps something that you have already explored during your studies?
No, this is not something I explored, unfortunately. The preparation of it all, it felt like we were teaching ourselves IP. We are not effectively coached by anyone. So whenever the problem kind of arises, we're just shooting off emails to lawyers that might have some suggestions for us. So, you know, thank you to those that replied. But it was fun learning about this, and I'm honestly very impressed by Elon and Jolin and the amount of things they were able to pull from: creative issues, AI, technology, digital, like black site, like it was just a whole host of issues. So you can tell that they were very well prepared in a lot of aspects on this question. So it definitely made it a challenge when you're in it. Thank you.
Thank you very much. Well, it's good to know that you were able to utilize the resources from the debate team of University of Melbourne, Ms. Jolin Bao. How did you find the debate, the preparation? Is this perhaps something that you already explored during your studies?
Yeah, so this is quite a special topic. I'm really interested in the IP laws. So I know a lot of like IP baristas, and also I talk about that with our coach, so get a lot of insights on that. Yeah.
All right. Good start for the resources. I hope that if the topic is interesting to you, that it sparks perhaps further exploration down the line for your professional careers or academics. From the University of Manitoba, Mr. Brown, how did you find the topic? Did you perhaps hear similar arguments from the opposing side that your team prepared?
You know, I think this topic is so complex and there are so many levels to it that, you know, great teams could each get this motion and come to a different conclusion about what it's actually, about what's important and what it's about. So I was impressed that my opponents took it a different direction that I had not even thought of clearly. So that was very impressive to me. And because I hadn't approached this academically in the past, we were somewhat going in blind, but it was a pleasure to research it. And once again, I had a great time. Congratulations and thank you to our opponents.
Thank you. From University of Melbourne, Mr. Ilan, how did you find the preparation, and did you perhaps hear similar arguments that your team prepared in the opposing side?
This was the first time that I really had anything to do with IP law, so it was really exciting to delve into an area that we haven't really touched on in law school, because when you study property, it's most of the time real property, so that's just what it is. But I do have to say, the Manitoba team, I was so impressed because a lot of their arguments were probably what I would prefer to be argued if we have legislation being argued in the real world. We don't necessarily want just carte blanche access to all our information. So it was hard not to smile and be like, yeah, I probably would be arguing the same thing if I was asked truthfully. But yeah, it was awesome. Thank you so much again for this debate.
Thank you very much. Closing for the feedback, Mr. Leicht of University of Manitoba, how did you find the debate, the arguments, your team's performance, the other team's performance?
Yeah, I'll mostly echo what my colleagues said. I really enjoyed the debate. It was great debating against the University of Melbourne, and it clearly a very well prepared team who knows quite a bit about intellectual property law. Once again, Liam and I are in our first year, and we haven't taken intellectual property law classes yet. So maybe in the future, but I think it's going to be a really important topic going forward. So but yeah, I really enjoyed it. Thanks so much once again for agreeing to rearrange things. I'm happy it worked out. Thank you very much. I'm not sure if you woke up for this or if you stayed up late for this, but regardless, thank you very much to the hosts as well.
Right, thank you very much. I must say, just on the sidebar, we have had a bit of experience from past years organizing matches about this time. So we came into this edition expecting that this would happen. We are happy to see that the students on both teams, that you had a chance to do it basically during the workday almost. So happy to give you the opportunity to do it at the full power. Right, it's been a pleasure hearing the feedback. It's been a pleasure hearing your debate so far. Once more, it's always inspiring experience as organizers to see the teams progress throughout the competition and see how they adapt. As per the information from the beginning, just before the live stream started, the winner of today's match will be facing the winner of the match that took place earlier today. So that would be the match between the Université française in Arménie and the Queen Mary University of London, who debated a somewhat similar topic, also dealing with personal image, but this time in the context of blockchain. So definitely interesting match to watch as well. As per usual, we'll be closing the match, seeing what are the potential connections between the two universities or the two countries for your teams. And on that note, passing the floor to my colleague.
Yes, indeed. Let's see, indeed, what are the possible connections you may have yourself or your institution eventually. So, Mr. Brown, have you been in Australia? Do you have maybe some connections, some friends over there?
I do. I've had the pleasure of going to Australia with Stefan, actually. Believe it or not, in high school, we went to Australia together. So we've been to, unfortunately, I don't think we made it to Melbourne, but we got to Sydney, Cairns, and Brisbane and Noosa. So it's a beautiful, beautiful country. And I think the best, Australia is like Canada, but just good weather. It's the best of Canada and a beautiful, beautiful country.
Okay, good to know. So yes, so it will be maybe a possibility to have connections even after this match between the two teams. Miss Bao, have you been in Canada, or do you have some contacts or friends or family or connections?
Yes, so I have some friends living in Canada, like in Toronto and Vancouver, but not in your city. But I'm love to visit the Canada and then do a trip there. And the closest one I went is Boston, probably close to your city. Yeah.
As close as anything can be in Canada.
Yeah,
which is a
yeah.
couple thousand.
That's right.
Yeah.
Because Australia is always far from anywhere else.
Yeah.
So I need to make a trip to the North America there. Yeah, one day.
Okay, so yes, so maybe some invitations after this match. Miss Gutierrez, then, do you have any connections, or have you been in Australia?
I've never been to Australia, unfortunately not, though I definitely want to, despite the very long flight and all of the crazy posts I see online about the bugs and everything, which you can confirm or deny. I don't know. No, but I would love to. Though I did scope out a previous match, and if I recall correctly, I think Elon is from New York, which I am a big fan of and have been to several times. So that's probably as close a connection as I'm gonna get to.
So yes, so I see indeed that you have been watching match and as well identifying the strategies maybe from previous match. So very good. And of course, Mr. Lesh, as you have been then in Australia, from what I understand, and yeah, what did you like the most, and would you like to come back, of course?
Oh, I would love to go back to Australia. That would be a dream. Yeah, hopefully sooner rather than later. Liam and I loved our time there. It was fantastic. We were in grade 12. It was actually for a debating tournament in grade 12. So it worked out that the next time I interact with an Australian university is in a debate format again. But yeah, I really enjoyed it. I didn't get a chance to make it to Melbourne. I've heard Melbourne has now surpassed Sydney as the largest city in Australia, so congratulations to my colleagues, and I guess that means it's got to be top of the list next time I go.
Okay, very good. And finally, Mr. Ilan, then in Australia, have you been in Canada, maybe in Winnipeg?
Yeah, so I was born in New York City, but I'm a New Jersey boy, so let's go Devils. It's hockey playoffs right now, so my connection to Winnipeg is probably Travis Zajac. He's a good boy from Winnipeg back in the day. So yeah, I know a lot about Winnipeg just because virtually through watching on TV. I've never been, but maybe if the Devils or Jets ever play in the Stanley Cup, I'll have to come on over to Winnipeg for a game or two.
Yeah,
and they'll host me.
Schneider also played goalie for the Manitoba Moose when we didn't have an NHL team. So
yeah, there we go. So yeah, I guess there are connections like that. But yeah, I've been to Toronto a bunch. But yeah, being from New Jersey, Canada, I just kind of wave at the big brother up there. So yeah, it's all good. But yeah, come down to Melbourne. Sorry we don't have Australian accents. I know it might have been the hope with today, but we'll introduce you to some people that do have them.
Oh, good.
Okay, very good. So I heard only one thing I know from ice hockey, the Stanley Cup. So yes, because I'm not from a country where we play ice hockey. So, but my colleague is from a country, I mean, in Slovakia, where they play a lot of hockey. So yes. So of course, after this match, you can email us and we can put you in contact. And yes, so what will happen in the next days? The free judge will be assessing the match. Maybe they're watching at this moment the match, and afterwards you will receive the result. Obviously, around 2 weeks from now, there will be the quarterfinals match. Another thing as well we mention is in case, even if the distance is huge, but you are thinking to come to the Netherlands for the final week, you are welcome, and you can let us know, of course, by email. And yes, this I would say competition as well. The results, I mean the performance you have concerning this current competition will be as well giving points for your university on the international ranking we have concerning moot courts and debate competitions on a website that we are partnering with. So it means that yes, what you are doing and what you will be doing in this competition, that will be as well helping your university to get even higher in the ranking nationally, internationally. I mean, together with other competitions, I mean, Jessup, VIS, etc. So that is something which is new for this, I would say, edition that you will hear about a bit more, of course, during the next days and weeks. So I will give the floor now for the last words to my colleague, and of course, it was very good and well done, and I hope that you enjoyed that topic very much. Yeah.
Thank you very much, and I can only reiterate what my colleague said. Indeed, we are really happy to partner with the organization that provides the rankings also in regards to participation in moot courts and international law competitions. So definitely keep an eye out on that. And I already see that you took a note of different matches that were happening in the competition. I highly recommend also all the debates that took place in the 8 finals so far, personally. This edition is really high level when it comes to debates as well as next year's. It feels like every edition is trying to high up the previous one. I believe that you've had a good experience, that it motivates you further in your studies and professional careers. And most importantly, that you had fun and opportunity to connect with fellow students from across the globe. On that note, best of the day to you both, to both teams, and have a good rest of the week.
Yes, many thanks.
Thank you.
See you soon.
And to you.
Thank you. Bye-bye.